Ladies and gentlemen, boys and girls, you saw the thumbnail, you saw the title. So let's get at it. To say that 2024 has been a year of just an abundance of content coming in would be an understatement of the year. I can't even begin to tell you how much wild content that I've seen. And this has just been amazing with the amount of stuff that we've seen just literally in the last couple of days, not even the whole month. I mean, we're literally in the clutches, the early clutches of March, and it is coming in like a lion. Absolutely. So thank you so much for tuning in on today. We're going to look at the Ashliee Merchant testimony. We're going to look at parts of it. We're not going to look at the whole thing because it was extremely long. And there was just so much good stuff in there. It was really hard to figure out what to cut out. So I found a couple snippets I thought would be very helpful. I did find something that was a little bit troubling. That's actually not even dealing with Ashliee Merchant. So I'll be showing that first. And then we're going to look at the senator who push back and ask a lot of questions of Ashliee. We'll look at that one in a deep dive manner. So thank you so much for tuning in on today. Shara's in the building. Good to see you. Grace and peace, Sister Grace and peace. Good to see you. Always good to see Q in the house. Thank y'all so much for tuning in. I know it's been a busy day. I think we literally started this morning, and lo and behold, the testimony started on time, and we were like, yo. So we actually watched a lot of the opening together. So I tried to pull out some parts that we missed, and especially that pushback from, I think his name's Senator Brown here in Georgia. I thought it was useful, so I thought we would look into it. So before we get too far afield, let's go ahead and pull this in. Notice that Fani Willis is running again for her office seat, and this is actually her being certified to run again. So she's actually met all the qualifications to run again for DA. And so we're going to just listen to her. The reporters asked some questions, and interestingly enough, Fani was very candid. Put the date on your videos. Okay, I will check that out. Thank you, Mary. Thank you so much. I will make sure to do that for sure. Let's move forward. Let's go.
Excited!
Hi there. Can I talk to you real quick?
Yes.
First, let me ask you about qualifying. Tell us what it means to you.
It means everything. I didn't think it would be as exciting, but it turns out the second time is still a charm, and I'm really excited. I've said it before, being the district attorney in Fulton County is the greatest honor of my entire life. I love this community. It's my home. It's where I raise my children. It's where I want to keep safe. I'm honored to serve. I'm honored for just the outpouring of support that I continue to get. And I am so excited to be here again today. I feel giddy.
What's your perspective on the efforts, particularly in the Georgia Senate by Republicans, to reprimand you and to scrutinize you, to investigate you?
I think it's all just a political quest. I think that people are angry because I'm going to do the right thing and I'm going to stand up for justice, no matter who is the person that may have done wrong in Fulton County. And so they can continue on with their games, and I'm going to continue to do the work of the people.
If you're called before the committee.
Okay, real quick. I just want to break in real quick. Over Fani's shoulder, you may or may not know, that's former Mayor Shirley Franklin. I was looking like, yo, that's Shirley Franklin. She's really short. But she was mayor here, man, after Kasim Reed. So it's got to been, I have to go back and look, man. It was the early 2000s. But yeah, that's former Mayor Shirley Franklin.
Will you appear?
I will discuss that with my lawyer, and me and my lawyer will make a decision, and whatever decision he advises is the best I'll make.
Did you watch the hearing this morning?
I did not get to see all of it. I had pieces that people were watching, but no, I didn't have time to sit for 3.5 hours, I understand, and went and watch. I did not.
What's your message to any prospective challengers who might run against you on the Republican or Democratic side?
I think this is a democracy we live in, right? So people have a right to run for office, but they should come prepared for a fight. They should know that my heart is still in this work. My heart will continue to be in this work, and I intend to be the DA for the next 4 years and 9 months.
Judge McAfee could rule at any moment. Are you feeling confident in your defense of this motion to disqualify from the case?
That's where I don't want to comment because it's commenting on an active case, and so I won't comment. But I think we presented the law, and
I think it's adorable. She says, I don't want to comment on an active case, but, and then she goes into explaining, like, you could have just said that.
Always hopeful that a judge will make a decision that is in line with the law.
Thank you, ma'am. Thank you.
All right. All right. So that was the first of many clips.
Well, today's state senators called on a key defense attorney to share what she knows about the Georgia election interference case and the
Yeah, this newscast, I'm starting to like this newscast here in Georgia. It's called Atlanta First. I'm not familiar with them. It seems like they're internet only, but I'm actually kind of digging them. I find that they've been pretty good. So they've been a lot of help. Actually, I think I have another clip of them as well. So anyway, let's go.
prosecutors handling it.
Members of a Republican-led committee want to know whether Fulton County District Attorney Fani Willis is trying the case fairly. Recently, in a separate court proceeding, we have heard allegations of improper financial gain and forensic misconduct with a limited scope of evidence. But at the Capitol today, a different set of rules put far more testimony on the table. That's where we find 11 Alive's Grace King tonight.
All right, so Grace, where does this special committee that we heard from fit into all of this?
It's a Republican-led investigative committee that has the power to subpoena witnesses, review evidence, and make legislative recommendations, but that's about it. It doesn't have jurisdiction over the ongoing court case or the efforts to remove District Attorney Fani Willis.
I think it's all just a political quest.
Fulton County District Attorney Fani Willis responding to an hours-long hearing at the Capitol.
They can continue on with their games, and I'm going to continue to do the work of the people.
The Georgia Senate Special Committee on Investigations subpoenaed defense attorney Ashliee Merchant, who's asked the judge to disqualify Willis and her team from trying the case against her client, Michael Roman, former President Donald Trump, and several co-defendants.
Those are troubling allegations. And so our job here is to try to get to the bottom of this, prove whether or not it happened, and see if it's in violation of Georgia law.
They asked Merchant to walk through the evidence she's produced, like copies of invoices from Wade that she felt were too vague and too high.
You have to be detailed in your bills because that's accountability.
Cell phone data that appears to place Wade near a condo Willis rented nearly 36 times the year he was hired.
It's geolocation.
And text messages between herself and Terrence Bradley, Wade's former law partner and one-time divorce attorney.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely.
Merchant says these documents prove Willis and Wade began dating in 2019, creating a conflict of interest when he was awarded a contract worth hundreds of thousands of dollars. But Willis and Wade say no conflict exists because they began dating in 2022.
There's no conflict in that case. That's what the law says. That's what the law has always said. And it's kind of embarrassing, quite frankly, that this state is going through this.
All right, so that's
And the chairman of that committee said he'd like to hear from DA Willis at some point. Now, whether that's at the next hearing in a couple of weeks, we'll just have to wait and find out.
All right, Grace, thank you so much for that explanation. Now, if you missed it.
all right. So that was and I'm sure you all have seen, like, the hearings were extremely long. They allowed Ashliee to really explain and really tease out all of her processes and such like that. It was very informative, I have to say. I now feel even more confident that there's going to be some ramifications. I think people are just trying to posit. I think there are people who support Fani that are just trying to, like, positively confess that it's not going to happen. And I think they're going to see, because the stuff that they talked about today was, it's hard to say that they're going to be able to pull that off, anything else. And for her to say that they reported on the law, they explained the law, was laughable. I'm sorry, just to say the least, because I think everybody saw, like, that was not the law that they were explaining. But let us get it on. Let's go. So this is one of the segments from 11 Alive, and let's just see what they got to say. Let's go.
Help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from.
Shame on you, Augusta.
I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this, and one of them said they haven't done it in years, but they have done it, and they paid between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor, and that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it, and so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues, and so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts, if there's a conflict, and if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have, the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners. You've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it, and it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those, and so those are who I sent all of those.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done
Fulton
it.
County is one of them.
Only 2. Yes. I'm sorry. It's 3 counting Fulton County. Okay. I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may. I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the prosecuting attorney's counsel early on in this case, and because I was trying to figure out the legality of this. I did open records, and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what, I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18. The one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something like that.
What is that statutory
statutory,
It's,
right?
I don't know it off the top of my head, but it is in the statute. I know that, like, District Attorney Willis, for example, I think it's around $200,000, and that's, that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that.
Keep in mind, Nathan had been working for 2 years. So he's made $600,000 in 2 years. And I don't think it's been a true 2 years. I think I even heard that it was a year and a half. So he's made 3 times as much as Fani makes. Just think about that.
Depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money. But they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually open records that, and it was declined. So we actually have a pending open records lawsuit. Which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Help walk.
All right. So that was just the start. And as many of you are picking up, like, yo, Nathan, this is money that they hadn't even started the trial yet. So if this had gone under the radar, it's very possible, extremely plausible, that Nathan would have been pulling in several millions of dollars had this gone to actual trial. Somewhere during the interview, Ashliee brings up like his billing. I mean, he was able to bill $35,000 a month in billing, because they have like limits, certain limits that you can only bill as much. But because he was because of his role, he was able to bill far more than others. Like it was wild. All right, let's go. We got another quick segment, and then we're going to listen to Senator Jones. He's going to tell us what he really thinks about this, and it's pretty insightful. So let's go.
In this, I'll begin. Ms. Merchant, you are here under a subpoena. Testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right. So, well, if you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's saying anything, let me know. The way our procedures work is that I will be asking the questions, and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion, or maybe even at a break. If you want to, just let me know. Ms. Murphy.
Okay, so this was the opening salvo, and I thought this was a different clip. I apologize, but this was the opening where Ashliee kind of gives her bona fides. She takes her pledge and her oath, and they kind of set the stage. And I thought I had some more of the fiery comments, but I'll have to make sure I have those for the next live. But let's finish this up. But we also have Fry tonight too, so we got Viva Fry, so he's going to take care of us.
Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, et cetera.
Definitely. My name is Ashliee Merchant. My first name is spelled Ashliee. last name Merchant, M-E-R.
You're going to need to pull that mic
I'm
a
sorry.
little closer to
Thank
you.
you.
So
And is it okay? I have a notepad just in case
You're
I get
absolutely
two
free.
questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, et cetera. But since you are an attorney, apparently you're very comfortable responding. Okay,
Yes.
didn't mean to cut you off.
That's
Let's just
okay.
make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004, so I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights, and then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes, yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive award about my work defending the Constitution.
All right, so that was Ashliee starting off. Okay, so I got these clips from a peer, and I thought they were different. So I'll make sure, I apologize about that. I will make sure that I have some better clips. But I know this one is going to be a great clip, and this is going to be Senator Jones is going to be pushing back on Ashliee. You probably have seen a lot of Ashlee's testimony already because everybody has been swooning over it. I want to point out, not a lot of people are talking about Jones, so that's why I wanted to do this one. This one's a little bit longer. We'll be stopping and going throughout. Grace and peace to everybody who stopped by tonight. Thank you so much for stopping by. Thank you for hitting that like button on the way in. Thank you so much for commenting in the comment section, or in the chat rather, and letting everybody know who you are and that you're in the building. And let's get at it. Let's go. We got a lot to do. Let's go.
On one issue, in your brief, the most recent one that you filed.
The second one?
Right.
Okay.
On page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath,
right?
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed, and in and of itself.
And apparently, look, we're going to probably push back on Senator Jones quite a bit, so I don't want it to sound like I'm picking on him just because. But for some reason or another, he's breathing into the microphone extremely harsh. So that's not me. I don't want y'all to think like, I know I'm a nose breather, so but that's not me breathing. That's him. He's breathing really hard into the microphone. But I'm not going to talk about that. I'm going to talk about some other things, but let's go.
That's not that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order. But I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right, now I was just kind of showing why I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that in some kind of way this creates a conflict of interest. And, of course, the judge is going to rule on that, but I still think it's important to kind of go through it.
So, a couple things. So, I don't understand how fairly intelligent, really intelligent people, I'm giving everybody the benefit of the doubt, can argue that if a woman is having an intimate relationship with a man and hires said man to work under her and pays him far more than anyone else gets, that would not be a conflict of interest. I don't understand, and it makes them look foolish because, as I've said before, they would have a problem if this applied in their own work environment or their spouses or their kids' first job at McDonald's, whatever, or their church. They would have a problem. They would have zero issues. They would have no reason to do all of this hand-wringing and all of this navel gazing. It's just really dumb. But let's let him go because I got this bad feeling it's going to get worse.
And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
We can't hear you.
I'm so sorry.
Just
I'm so
pull
sorry.
the microphone
Yeah,
just
of
a little
course.
bit closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
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 Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24, okay.
And, Willie Doc, shout out to Willie Doc. Why do we have to explain to you that the law is that there's no hint of impropriety? If you go back and listen to McDougal's closing argument during the closing argument segment of the case, he gives a story about Caesar's wife. And the skinny is Caesar, we know, would be the emperor. His wife has to hold herself circumspect because she is his wife. And so therefore she can't have the hint of impropriety because she is Caesar's wife. And that's why they call her Caesar's wife. They don't call her Sarah or Patty. They call her Caesar's wife because her role, her relationship to her husband determines her role and the importance thereof. This does not seem hard and complex. Again, they would not tolerate, I guarantee you, wherever Senator Jones goes to church, he would not tolerate this. Well, no, I do take that back now. He might tolerate it in his church. And I don't know who those men are sitting behind him, and I don't like the way they are either. But, praise God.
So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me. But essentially, to answer your question, that first of all is physical presence only. So
right.
yes, and we
but you did cite it
and said
right.
that.
So you mean to tell me that Fani Willis has no vested interest in locking up Donald Trump? No vested interest, nothing at all. It's just another day at the office. Okay, all right, that's what you want me to believe. Sure.
It's physical precedent only.
And you're using that as the basis, really, to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. That. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent.
So Karen asked this question. I think the overall argument, because this is kind of what they argued in the closing, if you waded through that verbal soup that Avati spewed in the closing arguments, they're trying to say that because there's no case law that says, this is what I'm understanding. And so if you are a legal expert, feel free to come in and let me know. Basically, there's no example or case law of a prosecutor hiring her or his boyfriend or girlfriend, their extramarital lover, to work on a case. So therefore, there's no conflict of interest. That's basically what they're arguing. And so Jones here is arguing that, well, where do you get this from? Because this is actually all new territory. Let's just tell the truth. So all of their recommendations, all of their case law examples are going to be slightly different because they don't actually have this. There's no precedent for what we're seeing. So they're blazing a new trail. Now, in 20 years, they'll be referring back to this case, or they'll be referring back to this investigation, or if she gets thrown off the bench or thrown in jail, they'll be referring back to it. But this is all fairly new. There's not a settled law or case that they can refer back to. So they are referring to a lot of general cases. And Jones is trying to point out, well, this case isn't an apples to apples. So therefore, why are you talking about it? That's basically what he's saying. And that's how Avati attempted to dunk on them on Thursday during the closing arguments, was that there's not an example. So therefore, all the other examples are not going to be a perfect fit. So you got apples and, you got a perfectly round apple and a slightly deformed apple, or you got a perfectly round apple and a extremely large apple, whatever. They're still apples. So that's what I'm understanding his complaint to be. But let's continue.
You.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only. And I don't remember the specific facts of that case, but it's not just a conviction. And obviously the state wants it to be just a conviction. And we argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case. So
That's
that was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake, actually, really in the conviction, because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake and just bringing the case, because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well,
no. See, I know a lot of you all are pointing this out. Like, no, this woman, this Fani Willis, wants to bring Donald Trump to task. I mean, that's what she wants. There is a personal. She receives something personal from that. It doesn't have to be an apples to apples or coin for coin example. I think he knows that. I know he knows that, but let's let him continue.
Well, so amusement's a little bit different because there is no conviction in a forfeiture act.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
But they don't get money for bringing it.
So I just want to.
But they have gotten money. And that's why she spent so much time explaining about Nathan's exorbitant pay and the trips that they've taken. I think he knows this.
To make sure it was clear
right.
that was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking as far as
give.
this issue is concerned.
And let's also, like, why is he ignoring the fact that the only reason he has a job is because he's sleeping with Fani Willis? Why is he ignoring that? Why is he not bringing that up? Like, oh, see, this is how you know that they're not fair dealers. I mean, the only reason they're having this discussion is because he's been sleeping with Fani Willis. Otherwise, I don't think anybody would even care. There would be no discussion if he was getting paid this much and wasn't sleeping with Fani Willis. Let's say she hired some prosecutor from Oklahoma to come. Nobody would care. We would not be having this conversation. We wouldn't be. It's because he's been sleeping with Fani Willis. And he's trying to make the conflict to only be what happens in the courtroom and forgetting what's happened in the bedroom. Like that, he can't be this obtuse. He can't be.
Right here, when you use the with worth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can.
Why are you?
Because in
Whitworth,
Whitworth,
there's not a conflict.
The person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was, the defense attorney came to the prosecutor and said, we would like to plead. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor, we want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
So there's not an unfairness that the prosecutor and the DA are having an extramarital affair. Make this make sense to me. I'm sorry. I really like Ashliee Merchant. I don't think that she defended herself properly, because she should have just put her little book over to the side and said, my man, are you honestly trying to tell me that there's no conflict here? And she should have pushed back on him rather than asking the questions. But I can't see how, like, this is dumb. But that's okay. I heard it actually gets worse.
Can you point to any unfairness in the trial that's taking place?
It's not.
That you're sleeping with your boyfriend, that your boyfriend is the prosecuting attorney? I can't think of what could be wrong with that.
The trial. So it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end. It would be no more billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client so they can continue to.
How is he missing the fact that Fani Willis, Nathan Wade are involved in an extramarital affair? How is he totally missing that? I understand Ashliee Merchant is the guest in the gallery, so she has to, have a level of decorum. But to me, this is so ignorant because he is wrong and he knows he's wrong. I'm sorry. There's no way he can believe that he thinks he's right, that he would be okay with this story playing out any other way, as I've said before. Let's get done.
Bill. Well, he basically went out and said, I'm tired of billing. I'm going to offer a misdemeanor.
Okay,
and you said no.
Take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really 3 classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in D.C. Then you see the electors. Then you see coffee. These cases could have been handled.
Ms. Merchant, we can't even hear you.
Oh, I'm so
here.
sorry.
Just pull it
I didn't.
up right
Sorry.
to you. Pull it to the edge of the desk if you have to, so everybody can hear.
Sorry. Okay. So how I was trying to explain it is I separate this down into 3 different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that.
Yes.
The stuff with the federal.
We do have a county here in Georgia called Coffee County. There is a county called Coffee County. I don't know why. That's a good question. I hear y'all asking that question. Go ahead and type coffee in the chat. Go ahead and type coffee in the chat. There you go. Extra credit if you get a coffee emoji. Let's go.
Federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all 3 together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these 3 different classifications. What does that do? That means the trial's going to be a year. They can plead people out. They can plead Michael Roman out, they can plead this person out, they can plead people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation because imagine if we just had, like you see in other cases, one defendant. You can limit the information to just that crime and that case. Or you could have 3 separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have 3 trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not.
Which one? Whitworth?
Whitworth. It says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth.
He is really, I'm sorry, I don't think he's being honest. He is really trying to argue. When Abati, during the closing arguments, made so many missteps, so he stated so many case law examples where literally Judge McAfee says, that doesn't apply here. And he said, well, yeah, Judge, I do know that. And then try to continue to shoehorn it in. This gentleman right here, and I know he knows what he's doing, cannot be honest enough and say he's trying to stick to the letter of the law or case law examples when we've already ascertained that this is a brand new frontier. This is a whole new place. We've blazed a trail that we've never been before. So why is he acting like this? I mean, he's trying to retry the case, as M has said here. He's trying to. You want the organ sound for her answer? I got it. You know what? I didn't even have my sound effects ready. And I've spent a lot of time getting those ready, and I did not even do it. All right, there we go. Let's finish this. All of them are. Don't buckle, Ashliee. Facts. That's it. Like literally, that's it. It's $100. Period. That's the law. What else are we talking about? What else are we talking about? Good gracious, man. That is not me breathing. There we go. That's it.
About my motion.
Oh my gosh.
In this case, it was actually Nathan Wade. So he's the one that
Wait, hold on.
presented
Are you
most
trying
of the
to tell me that this
witnesses.
is not-
Presented
How is your
most-
client charged? How are these clients charged?
Hold on. Y'all, oh wait. I'm sorry. Y'all didn't hear me. Y'all been only hearing me. And this rascal's snoring on the line. All right, let me back up a little taste. I apologize about that.
is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution. We definitely have seen a stake in the prosecution. And you know, Whitworth, the problem with Whitworth, and this is...
Who actually brings the case?
The district attorney. Well,
how do they get the case?
Well, we know a lot more now because of the book, Find Me the Votes.
These questions are so asinine. Whoever is represented by Mr. Jones right here, y'all ought to be ashamed of yourselves. Y'all ought to feel some kind of way. Because the questions he's asking are not genuine questions that really challenge or dig into. I have to say, I think the initial interview, I forgot his name is the initial senator that was asking the questions, to me were thoughtful. These questions are just trying to get you gotcha questions to get you to stumble and say, Good gracious, man. I heard Jones is a deacon at Shiloh Baptist Church. Let me tell you right now, I'm looking it up. While y'all are doing this, let me look.
So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So he's the one that he presented most of the witnesses,
How is your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so a grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury.
Yes.
Who made this determination?
Well, yes.
They made a determination to bring charges, basically. To indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this, it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident, and the grand jury indicted him.
So you're saying the grand jury has flaws?
No, everybody knows it. Everybody knows that about the grand jury. Now he wants to challenge whether or not the Trump and the others should have been indicted at all. Is that anything remotely what they ask or they were asking about? So now he's going to try to get her to say one reason or another that the grand jury system is broken. The grand jury system is flawed in some way, shape, or form, so that he can go ahead and that can hit the media that Ashliee Merchant is challenging the grand jury. Forget the fact that Fani Willis literally said that CellHawk is a flawed system. And I'm sorry I didn't get that actual the clip, and hopefully I'll have it tomorrow or the next time we do a live, where Ashliee Merchant, the expert that Ashliee Merchant used, is the same expert that Fani Willis is using in her YSL RICO charge case. So for them to challenge the expert and say the expert doesn't know what he's doing, she's really undermining her own case. The largest RICO charge case ever in the state of Georgia is being tried right now, and Fani Willis may have very well yanked the rug from under her own argument by saying that the cell phone data, the CellHawk and the CellBrite are not trustworthy. See, but this is where your sins will find you out.
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the grand jury.
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. And they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment.
Correct.
The prosecutor brings that indictment, and then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process, personally, but that's for another day.
So you went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3 already.
And they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career, and I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualifications. So,
yes.
But you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right.
Shots fired. I got to do that. Shots fired. Shots fired. But wait, how is he ignore? He's going to totally skip over the fact that Wade has never been involved in a criminal felony trial ever. Let's just let him go.
Other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
Is that what you want to
That
go
would
with?
be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, and that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral in
that's
that.
not surprising at all.
And he's going to a grand jury, and you say he's integral in that. Then why even say that he's unexperienced? And he's getting people to plead guilty. But basically, you're saying those are just lawyers that don't want to do anything anymore, and they just pled their clients guilty.
So is he honestly telling me that he doesn't understand what experience is? Is that honestly? So he would go, let me just make sure I got it right. So he would be okay with going to a brain surgeon if he had a brain tumor, a very evasive brain tumor. He would be fine with going to somebody who was first year brain tumor doctor, specialist, compared to one who's 20 years in the game with countless surgeries under his or her scrubs. He would be perfectly fine with that. This man cannot be this obtuse. Jones, my name is Jason. DearWolkC@gmail.com. I live in Cobb County. If you got any problems, questions, concerns about what I just said.
I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular point. Very complicated case, I'd imagine.
I mean, that's something that we could debate. If walking someone through the grand jury, the special purpose grand jury is complicated or not. Asking questions, and again, there's a team of 10 lawyers. So
now there's a team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and restricted in their private law practice? Why do they need him there when there's all?
That's the question. Come on. See, Ashliee just needs a little bit of warming up. That's what she just needs, a little bit of warming up. Drop a fire emoji. I can't find one. I'm just going to write the word fire. She just needs to warm up a little bit. You see her, she's getting a little bit loose. She's ready, and she's giving them that work now. All right, drop a fire emoji in there if you can, or just write the word fire. She just needed to warm up a little bit. Now, mouth breather can go ahead and go sit down.
All these other people. As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent. There's no adversary. There's no judge.
Once it became adversarial, you've had persons start pleading.
No, nobody did.
And maybe more potentially, correct? Possibly. But we'll find out. But let me ask you this, though, because you were talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office would basically shut down. There's a potential that the DA's office had actually basically shut down.
Oh, God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
well, the inexperienced ADAs are not going to make.
Wait up. Y'all, who sent this thing to me? This man is a pure fool. Is he honestly saying that one Nathan Wade never trying a case of a felony case versus 5 ADAs is the same thing? This dude, you cannot be telling me this.
He's going to
$100,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation. His is on contract, so it's,
But they
it's
don't need
short
him.
term.
But they wouldn't need him. That's the thing. Yo, this is very disingenuous. And his math is not math, and this is girl math. This is girl math that he's using. He doesn't, it's almost like he doesn't realize Nathan Wade was paid this in 24 months. He was paid almost $650,000 in 24 months. Sir, that's not sustainable. I'm sorry. Now, they do go through later on in here and discuss, like, how do they pay and where's the money come from and all these kind of things like that. It was very, very informative. But he knows better than this. I'm glad this is only just a testimony. It's not a trial. It's not really the outcome. They'll decide what to do with the information after they've subpoenaed and talked to all these different people. But yeah, this is some, as K-Dub just said, this is gossip girl apologetic math. Whew, that's a mouthful. Mouth breathers.
It's not a long-term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could have used this money for that. But that money was delegated for him on the short-term project, so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond to this.
Yes.
What was that?
I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire.
Wait, $3 to $4 million. So that means she was planning to pay this man another $2.4 million, and the case has not, the trial has not actually started. So let's just go on the high end that it would have been the 4. Yo, she was cool with paying him 3.4 more million dollars. And please, again, keep in mind, he's already secured 650 and it's only been 2 years, less than 2 years, actually. Yo, that is out of control. And we're wrong for calling this out? And we're wrong for that.
Ain't nobody got time for that.
Hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all.
Right.
Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, "Hey, the contract because he works at her pleasure."
Oh, yes.
So that contract can actually end at any time.
Right. That was not.
Yes.
That was inappropriate. That was so inappropriate. How dare he say he works at her pleasure? I'm gonna back that up because that was inappropriate. Shame on you, Jason.
Contract. So in that sense, is delegated to him because that contract can end at any time. She could say, "Hey, the contract because he works at her pleasure."
Oh, yes.
So that contract can actually end at any time. That would be the point.
That's so juvenile, Jason. That's so juvenile. I'm sorry, y'all. Whoever is represented by Senator Jones, y'all need to tell this man first of all, his comprehension skills are trash. They are non-existent. His critical thinking skills are on life support. This is ridiculous.
Yes.
On the trips, how much total were the trips?
About $20,000.
And I think it was about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
Well,
wait, this is another thing. Hold on, wait. You do realize that Nathan Wade took Fani Willis on 3 cruises in the span of 2 years. And not even a full 2 years, because this stuff is hit the fan at the end of last year. So he's actually taken her on 3 cruises. And hear me, I'm Team Cruise. The Whitaker family loves cruises. That is a lot of cruising. That's a lot of cruising. When were y'all working? I'm sorry. She is not pushing back enough. I'm sorry. I like Ashliee. I like her bravado. I like how she presents herself, but she should be pushing back a whole lot. These cats went on 3 cruises. They went to Napa. They went to Belize. Look, we need to start looking at how are you billing? Like, how are you billing when you're traveling so much? Yeah, he's just looking at it like, hey, 17 grand, like that's not a big deal. Wait, are you trying to tell me, do you really want me to believe that? Okay. It's a Fani cruise. Let's go.
They did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but...
Going by your slide, one was 3,335, one was 4,453.
Which one? Hold on, I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said
trips
one is 3,000 something. I want to make sure I'm clear.
2 years.
Yeah, put it back up.
And we're not including, and they're not including the trips like when they said they went to South Carolina, or I'm sorry, Tennessee or to Florida or wherever like that. They're not including those trips. They're not including going to California. They're not including Texas. They're just talking about major money outlay trips. That's crazy. When were they actually working should be a much better question.
Place. Yeah. There we go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then we see the next one, and then the next 2. How would that compare? I mean, what is that so unusual on price points as far as trips are concerned?
See, this is how you know this man is mentally retarded. Who cares? Like, I can tell you right now, those are some cheap cruises. I ain't gonna lie. I'll tell you that right now. That is a very inexpensive cruise. It must have been a 3-day. Because if that was 7 days, it'd be far more. But again, do you really want, is she a travel agent now? You're okay with, like, he's skipping over. It's like arguing like, well, hey, Nathan was cheating on his wife, but he used a condom and he paid X amount of dollars for a box of 12. Is that a good price? Do you think that was a reasonable price to pay, $20 for a box of condoms? How about the fact that he's cheating on his wife? How are we having a conversation? This man is so disingenuous.
How would that compare? I mean, what is that so unusual on price points as far as trips are concerned?
It's unusual for a married man to be on a trip with a woman that's not his wife. That's very unusual, Senator Jones. See, they couldn't have me in here. They couldn't have me because we wouldn't have made it. We wouldn't have made it. Things would have been thrown because these questions are retarded. He's literally overlooking, and this is the problem that most Black people have. We overlook the sin because we're looking at somebody's skin. Boy, that's some bars right there. Give me that. Give me the air horn. He's overlooking the sin of this man cheating on his wife because of his skin color. Boy, come on, man.
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had 2 cabins. His mom had a cabin. They had an oceanfront balcony.
Shout out to Oceanfront.
For the Bahamas. I think oceanfront balcony is probably, upper middle, but I don't know that it matters. Flew, comfort class, not unnormal for a lawyer. I mean,
you know what maybe the average American spends on vacation?
Not this much.
Why?
You think?
No.
Have you looked?
Why is he supposed to know? Why is she supposed to know? Like, what does that have to do with anything? These are a whole bunch of gotcha questions. Oh, she doesn't know what the average American spends on a vacation. What does that got to do with anything? I don't understand. And we're supposed to be proud of this. This is supposed to be the high level of decorum, the high level of ethical pushback. Man, shut up. This is stupid.
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these
Facts.
trips.
There you go.
Well, you know, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief, because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of four. Well, at that time, they were taking 2 and 3 at the time.
That makes
so
sense.
That makes, that's about
no,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on.
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said $3,700 for a family of 4. That does not surprise me. For families that can't afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
So that's.
But they did it.
Yes.
This is half of that for 2 people. So you said.
But also keep in mind, he's saying the average. So he's trying to bring up the average. But you do understand, they went on 4 of them. She had 4, maybe 5 different vacations. Let me back up just a second so I can see this again. Where's the spreadsheet? I don't like this guy. I do not like him. 1, 2, 3. That's 5 vacations. Here, 2311. So if he's saying that the average, you try and tell me, you want me to believe, hold on a second. You want me to believe that they went to Belize for $2,800? That's that's less expensive than going to Napa. I'm sorry. I'm calling shade on her number right there. Yo, but this man is actually challenging her about he's okay with this number. Y'all, man, y'all pray for that man. That man needs Christ. Like he's literally arguing 2311. That dude is literally, no, that's 2311. We're back right here. There we go. All right, here we go.
So it's basically what the average American would do.
So that's.
Yes.
This is half of that for 2 people. So you said $3,700 for a family of 4.
Right.
This is for 2 people.
There you go.
Right. It's just 2 people.
Right. So
yes.
Yes.
So it wouldn't necessarily be half. It's 2 adults. Bottom line is, it's not extravagant. It's not lavish, is it?
The law only says $100. So.
But it's not lavish.
That's one of the reasons I didn't include all the Ubers.
Stay right
I
there.
quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas.
Stay there, Ashliee. Keep digging the fact that the law says $100. That's it. And as far as I can tell, going back looking at this page, what's that? 2505. Looking here, that's more than $100. That's all you got to say, Ashliee. That's all you got to say. That's more than That's more than $100. Period. End of game. That's it. I don't know what else we're talking about.
There was a hotel at the beginning of the Royal Bahamas. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year.
So your argument is that a person who makes $200,000 a year is actually setting up prosecutions to go on a trip that costs $3,500.
What?
That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise.
Okay, so he's saying, okay, I see what he's trying to do. He's trying to say, okay, yo, whoever sent this to me, shame on you. This nincompoop is trying to say that they are prosecuting all of this situation in order to get the money so they can go on a cruise. That's literally what he's saying. I'm going to back it up so you can hear it. He's literally saying the reason they're doing this is they drummed up this case so they can get some money to go on a cruise. But they both make $200,000. But he doesn't see the weirdness in the argument that she makes $200,000 a year and Nathan made almost $650,000 in 2 years, which would mean he makes more money than her. To me, he's being disingenuous.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says
and it
this
is cute that he keeps using the term speculation, because he's trying to use the same word that Terrence Bradley, that they used about Terrence Bradley. Excuse me, Terrence Bradley used it when he said he was speculating. So he's trying to use the same term to try to tie her in, because we know that Terrence Bradley was being dishonest when he said speculating. So he's trying to tie her in and say that she's being dishonest and using the word speculating. But she hasn't owned the word speculating. He has, but I'll just continue. This is silly.
The benefit that she got, and all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. If that's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So we did argue for about 3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No. As far as actual financial benefit.
So the financial.
Okay, I'm getting sick and tired of the mouth breather, but he knows he has the brief in front of him. He's just trying to find something small and says that the average American, average Fulton County resident spends this much on vacation. That's so nose blind.
Benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are on trips.
That's what's in the brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we have.
That's what I
that
did.
Person
yes.
is doing all of this for that.
Right.
Okay.
Oh yeah, and so what I included was what I had the actual hard proof of, and then some of it's attached to the brief, some of it I got by subpoena, so some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted, and there were a lot of other receipts that I had that I did not know for sure if they were joined, and so I didn't include those, and I haven't talked about them today.
Correct.
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff that's hard proof.
Correct. That. So my next question then becomes...
You need to stop and have some questions and get some Allegra.
Going to conflict as far as...
Somebody get this man some Claritin or something, some mouth tape or something. He needs to start breathing through his nose. He needs to be a nose breather and help your overall health, longevity, and so forth. Sir, you don't even make sense what you're arguing.
His salary is concerned, just curious. Is it the amount of salary that you really creates the conflict? I mean, because we get stuck on money a lot. So is the amount of salary that gets...
The irony that he just said we get stuck on money a lot after just excoriating her over an Uber is just, to me, that makes no sense.
Is creating this conflict in your mind?
No.
Or is just the fact that he gets any salary at all?
No,
You don't
it
want
has
him to get
nothing
paid
to
at
do
all.
with that.
Come
I
on,
did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
That's not true.
I do, because of the Fulton County laws. The laws say that they
I
can.
don't understand the county codes, but I'm talking about as far as like what the case law says, which is what the judge is actually going to. If they're not hiding that.
He knows that. You can tell from the fact that he's trying to find a way to wiggle around, because he knows the problem is the fact that they are in a relationship. He knows that. Because now, see, and watch this, because Ashliee Merchant is married to her husband, who is also on this case, and everybody knew that. So there wasn't a sneaky situation where like, oh my gosh, they're both named Merchant. They come out of the same Uber every day. Oh my gosh, they're married, they're together. Nobody's doing that. See, he knows that he's wrong. Oh my gosh, this is crazy.
that or against the Fulton County ordinances?
They were
do you
hiding it,
believe,
though.
They
do
were
you
hiding it.
believe that there's a conflict? If they brought it out and said, hey, we're dating, is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is that they brought it out, would it be a conflict in your mind?
If
Is it
they-
a conflict?
Here in a
And what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J,
Give them
we
that
wouldn't
word.
be here.
That's it.
So then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict.
No.
It doesn't matter if she disclose a conflict. If you just
No, it does matter that she disclosed it. And they know that. You can't do that. You have to disclose it. And he knows this. This man is not being this man is not being genuine. He's not being honest. You need the organ sound? He's not being honest. He's not.
Ain't nobody got time for that.
He's not.
disclose a conflict, it still exists. If you, and that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual...
But they wouldn't allow her to do that. Ashliee gave a perfect example. Like, hey, I'm sleeping with this man. I want to go ahead and secure $3 million to pay him to do this, that, and the third. We're going to go on vacation and go on trips. And she said, like, if they would be okay with that, then... But they wouldn't. That's the thing. They wouldn't. They can't do that.
Conflict where your client is harmed. Just because they disclose it doesn't end that conflict.
No.
So what you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot
That's not true.
waive
That's
a
not what she said,
conflict
though.
like that. You
No,
just could.
so-
If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
But she didn't
I'm
say
sorry,
that,
I
though.
don't understand your question to me. I don't know what
You
you're
don't
asking.
have a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said
didn't
we
say
would
that.
not
That's the
be
thing.
here if that had happened.
Right,
That's what
because
I
you
said.
wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
That, say that here. I got to back that up. Bars. I could give her that again.
We wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it, but if
she
it was
disclosed the
disclosed,
facts- hold
it's
on.
disclosed
If
now.
she
What is the
disclosed
conflict?
The undisputed facts, the facts that we all, your side and my side.
How is your
whoever's
client
side-
harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if we
Now, I hope he's not trying to say that the standard is that you have to be harmed by something in order for there to be some kind of conflict. I hope that's not what he's trying to say.
if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Oh, the statutes. No,
it's not a statute. Not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No,
I don't think there needs to be a case. There's actual standards in place. I don't know if you're legal mind, let me know. But there's standards in place. So therefore, like the $100, you have to report a $100 gift. That's not a case law. That's a standard. I don't understand why he knows this. He
It's
cannot
really
be
not
this obtuse.
surprising, honestly, because can you imagine this happening? I mean,
happens.
honestly, in December, would you have imagined this happening? I think most people wouldn't
All
have.
sorts of conflicts are taken up by the Court of Appeals.
I
and
can
Supreme
tell
Court.
you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I don't.
He's
I wasn't
billing
there.
hours because he's prosecuting the case, correct?
I
A case
would
that a
assume.
grand
I would
jury
hope.
indicted.
He was drafting.
I would
He was
hope
drafting.
that he's billing based on work that he's doing. I don't know, because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I
wanna
mean, words
speculate.
do matter when we say that she's not paying him in that sense. He's earning money for a case that.
Wait, words matter now? But you've been using the word speculating the whole time. Words matter now, but you actually ask her what is the average vacation for Americans, but words matter now.
He is in charge of prosecuting that a grand jury indicted, and that's where we are.
You're
That's-
correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender and every government official that actually exists.
Employees,
100%. And that he is part of that process. And he is prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says.
Which case? I'm sorry.
In Witten.
Witten?
Whitworth versus State, it clearly says the prosecutor should.
Okay, I think it's adorable. And again, Senator Jones, my name is Jason. I live in Cobb County, and you are an imbecile. He mispronounced the name of the case every time he says it. And I wanted to make sure I wasn't just hearing things. So I'm gonna back up a little bit. Notice that he says something, and then when she asks for clarity, he says it differently. He's been doing this the whole time.
In the case that you cited, it clearly says.
Which case? I'm sorry.
In Witten.
Witten?
Whitworth versus State. It clearly
Whitworth.
says.
He said Witten, and then he said Whitworth. If you go back and listen, he's been doing that the whole night to stumble her up and say something different so she doesn't sound like she knows what she's talking about, or to throw her off like, wait, this is a different case than what I wrote. Did I write about that? I don't remember writing about that. So he's been doing this the entire day. And I thought I was just tripping, but this is the last one. There's the last few seconds left. He's been doing it the whole time. He's disingenuous.
Says the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Whew. That guy is a complete, I'm trying to be gracious, but man, Jones is being disingenuous. Again, like, you can disagree and you can believe that Fani Willis is a square peg, but how are you overlooking the fact that she's literally in a whole bona fide relationship with a man that's truly married? How are you doing that? I don't understand it, but we'll overlook it and say, well, oh, she doesn't know how much a Royal Caribbean cruise is. That's insane. Oh my gosh. We got to do better than that, man. I think all right. I'm just looking through the comments. It looks like the vast majority of people can see that this guy was not being a fair dealer. And sure, we can argue about whether or not, to me, he was only arguing about things that are peripheral. Okay, she's sleeping with the man, but she paid him. He's being paid through the county. Why are you not talking about the biggest issue on the board? Sure, she hired this man, but he's never prosecuted a felony case before. So how is he super eligible? Super qualified? How is that? I think Ashliee should have pushed back. I don't know if that's doable in these kind of situations, but I think Ashliee should have pushed back and been like, "Yo, this don't even make sense." All right, but I gotta end on a good note. So we're gonna end with a friend of the channel now, and hear what Aviva Fry has to say, and I'm gonna get y'all out of here. So let's get ready to go.
All right, everybody, I promised you a daily wrap-up of today's hearing in the Fani Willis, Nathan Wade judicial scandal that is taking turns of epic proportions.
Epic.
For those of you who aren't paying attention, there is a current pending motion to disqualify Fani Willis and Nathan Wade from the RICO prosecution of Donald Trump and 17 other defendants in Georgia. And in the context of that RICO prosecution, one of the defendants, Michael Roman, represented by Ashliee Merchant, who is the subject of today's update, made a motion to disqualify Fani Willis and Nathan Wade after having discovered that the two were involved in a romantic relationship while they were prosecuting Donald Trump and others and getting hundreds of thousands of dollars from the state to finance Nathan Wade as an external prosecutor to prosecute this RICO case. The judge in that case, Scott McAfee, is currently adjudicating, deciding how to render his decision on the motion to disqualify, and we were covering that thoroughly. We don't need to go over that. Today, Wednesday, March 6th, Ashliee Merchant had been subpoenaed by a state investigation committee looking into the potential misconduct of Fani Willis in the context of her alleged conflict of interest and potential perjury and other ethical issues that she will soon be facing, if not tax issues that she will soon be facing. So this committee was started or formed in January. From what I understand, and as far as I know, Ashliee Merchant is the first person to have been subpoenaed to testify before this state investigative committee. It's bipartisan. There was some dude from the Democrat side of things, I guess, who asked some questions at the end of today's hearing. You could tell that he was a Democrat by the quality of his questions, and by quality, I mean the absolute insanity, idiocy.
They were wild.
Outrageousness of his incomprehension, lacking of understanding what was going on, and desire to just simply ram through grandstand sound bites that the media would run with and never actually listen to the answer. Okay, it's a bipartisan committee. They're investigating Fani Willis' purported potential alleged misconduct for the legislative purpose. They have to have a legislative purpose, I presume. I'm not sure if they actually have the authority to recommend criminal charges, perjury charges, or ethics charges, whatever. This is the first witness, from what I understand, that has been subpoenaed to testify to this state investigative committee, and it was Ashliee Merchant. It was a bombshell. It was 3+ hours of a masterclass of what a prepared, intelligent lawyer looks like. I should say intelligent, prepared, and honest lawyer looks like. No hemming and hawing, umming, oh, let me think of my law. Lies, not law. If only they were thinking of their law. This was a lawyer, intelligent, well-prepared, honest, who was willing to answer questions, who was able to answer questions, and who was able to retort the buffoonery coming from the bipartisan Democrat. What was his name? I forget what his name was. Jones the second. I forget what the Democrat name was. I'll find it and insert it right now. Ashliee Merchant is amazing. Period. She came out and answered questions.
I just thought about it. I think that's probably why his questions were so out of pocket, because she was so prepared and she did have all of her ducks in a row. So he asked her about chickens. She had all her ducks in a row. So he asked her about, Kias and, asked her about the weather in Finland and just the most randomest things. I really truly expected him to ask her, like, what was the weather while they were on the cruise? Like, it was that out of pocket. And maybe it's because she was so well prepared that he could do nothing more than just ask these really random gotcha. And like Viva said here, those questions that would cause the media to run in a certain direction. Let's finish up. Let's go.
Of this committee as relates to the alleged misconduct from Fani Willis, how she got involved in this relationship, when she was involved in this relationship, what would have been problematic if the allegations are true. This was not a court hearing. This was not to rehash evidence that was already presented to Scott McAfee, nor was it to look at evidence that was not submitted to Scott McAfee, although we did some of that. But I'll give you the highlights of this hearing. It lasted a little over 3 hours. You could tell that the person asking Ashliee the questions was favorable to her, to say the least. On the same political board, they insisted or asked, or at the very least caused this hearing to be live streamed. And it is important that it is live streamed so the world can see in real time, so that there's no media spin, potential media spin, misrepresentation, and people are unable to verify it on their own. It was amazing. The greatest thing about it, actually, is that it was basically a 3.5-hour summary of the 4 days of hearing and closing arguments before Scott McAfee. So if anybody was not able to follow that trial, or follow my coverage of that trial, or follow my summaries of my coverage of that trial.
Yes, Viva, we did. We did. Hey, everybody, if you haven't already liked the video, could you like the video? Help me out. I really do appreciate it. Let's go.
Trial. This would have been the perfect summary of it, and you're going to get a summary of the summary right now. Okay, Ashliee gets down, testifies under oath, and the details that came out that are amazing. I was jokingly saying that my first notes, as I'm emailing myself, taking notes while live stream commentating, was holy crap. The issue here is that Fani Willis is a district attorney. She was complaining in 2021, give or take, that she didn't have enough staff to deal with the backlog of cases that resulted from COVID, etc. You know, a lot of prosecutions, whatever. She didn't have enough staff to deal with the backlog of cases, so she asked the Georgia body, whoever allocates her budget, for additional funding to hire, from what I understand, up to or 55 additional staff, so that her district attorney's office can catch up on the backlog and prosecute the baddies.
Yeah.
Apparently, she was granted in 2021, in September through December, she was granted $780,000 to hire staff to clear the backlog and to prosecute the bad guys. What she did with that $780,000 that she was allocated for September through December, September, October, November, December, 3 months. Well, we know that she hired Nathan Wade in November of 2021. So she gets allocated $780,000 for the balance of 2021 alone, hires Nathan Wade, and doesn't apparently hire any additional staff. And then for the year 2022, from what I understand, she was allocated up to $5 million to hire additional staff that she never hired. Why is this important? She gets funding. She gets tons of funding, doesn't hire the staffing that was, predicated upon that funding, or at least was the basis for requesting that funding, and instead hires as external counsel her boyfriend that she has been stooping, now we know, since probably 2019. Why is this so important? A, she didn't fulfill the purpose for which that money was given to her, and B,
can somebody write stooping? How do you spell stooping? And that's out of control. Stooping. I don't know how to spell that. I think that's how you spell it. Stooping. Way to go. Way to go, Viva. Way to go.
She knew damn well that she could never hire Nathan Wade directly because it would violate a number of ethical issues. She would have to get specific clearance from whatever body it is that allocates the money in Georgia, clearance that she would not have gotten because of her relationship with Nathan Wade. So she goes to the state, asks for funding for one purpose, gets it, and then spends it in another way, that being on her boyfriend that she is knocking boots with for close to, a year and a half, 2 years, while she's taking these various cruises, getting gifts.
So it's a Yiddish word, really? Sorry, I moved my... That's a Yiddish word. Wow. Okay. Stoop. Really? Okay. I love this. See, that's what I'm telling y'all. That's the only reason I'm doing this, because I'm learning so much. If I wasn't learning anything, I wouldn't do any of this. I wouldn't be doing this. Thank you, Viva.
which she doesn't want to call gifts, but getting gifts from him. All right, that's one thing. Another reason why it was beneficial for Nathan Wade to be hired as external counsel and not as staff, even if he could have been hired as staff, which he couldn't have been, or she wouldn't have been able to get the money to pay him because of their relationship. One of the benefits of hiring Nathan Wade as external counsel, he would get to maintain his own private practice, whereas if he was brought on as staff, hired as an assistant DA or whatever they want to call it, he wouldn't be able to maintain his private practice. So in bypassing the purpose for which the funds were given to her, paying her boyfriend without running it through the requisite legal requirements in Georgia, she was also able to bestow on her boyfriend, Nathan Wade, the gift of being able to maintain his private practice, which, as we recall from the trial, amounted to roughly 50% of his income, even if it only accounted for a fraction of the actual work that he was billing for in that year. So an amazing perk that she was able to give Nathan Wade while she bypassed the legal ethical requirements of receiving funds and hiring external counsel. Another thing that was groundbreaking in this is the explanation for why Terrence Bradley, Nathan Wade's former family lawyer, Wade's former lawyer in the context of his divorce from Jocelyn Wade, Nathan Wade's former partner at Bradley Campbell Wade, Nathan Wade's former friend, we now know they are certainly former friends. The question that I had been asking for a little while, why would Terrence Bradley be collaborating, colluding, helping Ashliee Merchant in preparing a motion to disqualify Fani Willis and Nathan Wade? We got the answer. I think it might only be part of the answer. We got the answer in that Terrence Bradley, as I had predicted, allegedly according to some of the witnesses, was not preparing Nathan Wade's divorce proceedings, divorce pleadings. Nathan Wade was drafting them and then just asking Terrence Bradley to sign them. Terrence Bradley wasn't too happy with the fact that Nathan Wade was hiding all of these newly found assets, this very valuable, lucrative contract, from his wife as he's divorcing her. Apparently, according to Ashliee Merchant, Terrence Bradley did not like the fact that Nathan Wade was hiding assets from his wife, basically kicking her to the curb, dumping the kids off at high school, divorcing her, leaving her high and dry, while not disclosing, concealing this very lucrative contract from her. That's the reason Ashliee Merchant gave. I happen to think Terrence Bradley might have been a little burnt by Nathan Wade in that he now realized he was signing off on court proceedings that contained inaccurate, false lies basically. And now you have Terrence Bradley having signed off on court-documented lies, and he was pissed about that. I also have the feeling that Nathan Wade had cut Terrence Bradley out of his third of the very lucrative contract that Nathan Wade got from Fani Willis. And he was a little peeved about that. And I also have a little bit of an underlying theory here. Remember those accusations of sexual assault against Terrence Bradley? I have a feeling that in order to ensure the falling out, ensure that Terrence Bradley left, Nathan Wade might have orchestrated something of a coup, someone to falsely accuse Terrence Bradley of sexual assault to boot him from the partnership so that Nathan Wade doesn't have to split his third of that lucrative contract with Terrence Bradley. And as we now know, not only did Terrence Bradley actually get yeeted from the contract and his third of it, he had to sacrifice $20,000 that he had in escrow at Nathan Wade's firm to be paid to that employee who alleged sexual assault. So we now know that, according to Ashliee Merchant, the reason why Terrence Bradley was even cooperating with her in the first place, they were friends, they had a relationship that went back. It was because he didn't like the way Nathan Wade was treating Jocelyn Wade in the divorce, hiding assets from her, and then kicking the solo mom to the curb after he dropped his kids off at university. When it came to explain what was so absurd about the amount of money that Fani Willis had paid Nathan Wade under his contract, it amounted to like $700,000, give or take. Ashliee Merchant said if you were to hire skilled, experienced DAs, you would pay them a maximum of $175,000 a year. So you could basically have hired maybe seven internal employee DAs instead of paying out close to, if not more than $700,000 to her boyfriend while they are bumping uglies, involved in a relationship, taking cruises together. And it would have been more effective.
Fanny call. Please remember, it's called a Fanny call.
And they would have had actually a more effective result for that money being spent on attorneys to prosecute the RICO case. Ashliee Merchant did, I believe, testify to the effect that, we all know this now, Nathan Wade never prosecuted a felony in his life. He didn't even have the requisite experience to be the lead of the RICO case. They got into his billing, by the way. The fact that he billed seemingly not by the hour block, not by the 2-hour block. He seemingly billed by 8-hour blocks. Just flat 8 hours, $250 an hour. This is what I did. And When asked if Fani Willis ever scrutinized his invoices before paying them, the answer was no. He would just send these highly padded invoices and basically bill a retainer of $30,000 a month, which is what his cap for hours was as per the contract that Fani Willis gave him. It's wild. The other two lawyers in the case, who by Ashliee Merchant's estimation had more experience than Nathan Wade, Anna Cross, who is the one who's responsible for all of this having been blown up in the first place. Set that aside. Anna Cross and the other lawyer, Floyd, who by all accounts is a eminent RICO lawyer, they were being paid less than Nathan Wade. They were billing less than Nathan Wade. Nathan Wade billed, let's just say rounded up $700,000 over the course of his contract.
Yeah.
Anna Cross apparently billed, I think, under $100,000. Floyd billed, I think she said around 100, 150. I might be getting wrong with the numbers here to a T. Wildly less than Nathan Wade. And they had more experience, and their billing also, as Ashliee Merchant testified, was, to the 10 minutes, to the 6 minutes, not these day-long bill, not 24 hours in a day conference. Don't ask me any more details. Okay to pay. That's what Fani Willis did with each and every one of Nathan Wade's invoices. And he was basically hitting the cap every month, $30,000 a month, at a time when Nathan Wade wouldn't have been doing all that much work in the file anyhow, when the special grand jury had been convened and was looking into this, et cetera, et cetera. Nathan Wade wouldn't have even been working all that much at that point in time, and yet somehow he's managing to bill the maximum that he has been capped in his contract with Fani Willis at that time. Just a golden goose egg, or whatever it is. The goose that lays the golden egg is what this contract was, and they would have gotten away with it if it weren't for that meddling Ashliee Merchant. Ashliee Merchant went over the state law that required approval if Fani Willis was going to hire an external counsel, and she went over the fact that she wouldn't have been able to hire the external counsel if she had a prior relationship with them. It's just amazing. It's literally out there on the books. Fani Willis, corrupt to the core, but for reasons that we're going to even learn now that we thought we knew before, but we're now seeing the absolute hard evidence of it. You may or may not recall, during her testimony when Mr. Sadow, Trump's attorney, was asking Fani Willis, "You've been to Washington, D.C., correct? Did you ever go with Nathan Wade?" She said, "No, I never went with Nathan Wade. We might have overlapped, yada, yada, yada." And then Sadow asked her a very clear, very specific question. "When you were in D.C., did you go to the White House?" There was an objection from Abate, the very ethical lawyer who we now know attempts to suborn perjury from witnesses. I covered that in my stream. Abate objected, but Fani Willis, being a little too eager to conceal her corruption, said, "No, I did not go to the White House when I was there in D.C. because she had a very distinct memory of two specific trips to D.C. for two specific purposes, but couldn't remember one where she allegedly went to the White House. She denied having gone to the White House. Ashliee Merchant had the receipts that Fani Willis visited the White House. Maybe the front lawn in a tent. But when someone asks you, did you go to the White House? If you only went to a tent on the front lawn to meet the vice president, you say, yes, I went to the White House, and you don't forget about that meeting. Apparently, Fani Willis not only forgot about it, but when asked, did you go to the White House? She said, no, I did not, despite the objection from her ever ethical attorney, Abate. And then Scott McAfee says, well, I guess we got an answer regardless.
I understand your testimony is you never took a trip to D.C. with Mr. Wade.
That's correct.
Personal or business?
That's correct.
Were you ever in D.C. at the same time as Mr. Wade?
I was not.
Personal or business?
No, me and Mr. Wade have not been to D.C. at the same time. However, since Mr. Wade has been on this case, he's been to D.C. Since Mr. Wade has been on to this case, I've been to D.C. What has not happened is we have not been in the District of Columbia at the same time. Now, the only thing I'm not sure about with what you asked me is if I've been to D.C. personally, because I got a lot of personal friends in that area. But I know that I have been to D.C. I did an interview at Howard University. I went to D.C. for that.
Go Bisons.
Seems like I've been to D.C. one other time. Oh, I went to D.C. for the Global Summit. Actually, yeah, those were two separate trips.
My next question is based on her opening the door, and therefore I'll just ask it, and Your Honor can decide whether or not it's appropriate. When you went to D.C., did you go to the White House?
I did not go to the White House.
No.
I mean, there it is right there. There it is right there. Straight up lie. Just a lie. Just a lie. Just lying to be lying. Just lying. Let me insert.
A few moments later.
Well, apparently I'm going to get the answer anyhow. There you have it. Next question. Okay. When you went to D.C., did you go to the White House?
I did not go to the White House.
No. Well, apparently I'm going to get the answer anyhow.
There you have it. Next question. Okay.
Another highlight of Ashliee Merchant's presentation is how Fani Willis, in an attempt to undermine the cell data evidence that Sadow, I believe, Trump's attorney got, showing that, Nathan Wade was calling Fani Willis at off hours, driving to the cell tower near the condo that she was staying at, Yurdi's condo, staying until 4 in the morning. In an attempt to undermine that, Fani Willis was arguing that cell data is not all that reliable. I don't know if they don't realize or they don't care or they're trying to save their butts so much that they're prepared to undermine each and every one of the convictions, prosecutions in Georgia. But I have a sneaking suspicion a number of the criminals who may have been convicted based on cell data might be raising that very same Fani Willis argument in order to get their convictions tossed. Another amazing thing that came out of Ashliee Merchant's testimony related to something that was called an IOLTA. It's called an interest on lawyers' trust accounts.
This is very, I'm going to find that segment from the lead attorney. The lead attorney explained this IOLTA account, which cannot be touched. It cannot be touched. It is where when a client retains a lawyer, they put the money in that account until the lawyer has actually earned it. So if you pay Viva Fry $8,000 to do something for you, he puts it in his IOLTA account until he's actually earned it doing $8,000 worth of work. So then as he draws that money out, then he'll tamper down the balance in the IOLTA account. Apparently it's a big, you will get instantly disbarred if you mess with the IOLTA. I don't understand all the ins and outs. Lead attorney was explaining it. Now, the reason I bring this up is because Fry is about to explain what Nathan Wade was doing. He was literally putting his own paycheck into his IOLTA account, which you can't do because the money that is in the IOLTA has to be coming from a client. And of course, if you don't have a client or it's not money from a client, you can't just put money in there. He was hiding money in his IOLTA account. This is going to be crazy. Watch this. Well, before we watch it, let me go ahead and pull it back in. And now we can watch it. Make sure you like the video.
Money in IOLTA to avoid paying taxes on income is my note. Because it turns out that Nathan Wade, it would seem, was taking the $35,000 that he was billing monthly with his cap and sticking it in his interest on lawyers' trust accounts, so that he wouldn't necessarily have to declare it as revenue as it came in, and he could choose to declare it as revenue, perhaps when revenue would be a little lower, so he'd pay less taxes on it. And so he was basically using it as a conduit, apparently, allegedly, from my understanding, to potentially avoid paying taxes at a specific time or paying preferential taxes, and using the IOLTA as a bank account, which, according to Ashliee Merchant, is absolutely wholly inappropriate, unethical, and could get you in a lot of trouble now that it's disclosed. So after this masterful presentation, I mean masterful because Ashliee Merchant is eloquent. She doesn't hem and haw. You know that she's telling the truth, but more importantly, you know that she knows her file. It is night and day. It is the starkest of contrasts that you could possibly get to the hysterical, frantic, and above all else, dishonest Fani Willis, Nathan Wade, Terrence Bradley, sitting there on the stand. Did you ever go to a cabin with Ms. Willis? 18-second pause. No. Ashliee Merchant is the exact opposite of the district attorney's office in Georgia, and it's palpable, it's visible, you can tell, and it's embarrassing. The bottom line, this has been aired to the world. This is an embarrassment to the state of Georgia. It's an embarrassment to the district attorney's office of the state of Georgia. People were asking me in the chat, is Scott McAfee watching this? There's nothing that I think could preclude him from watching this. I hope he was watching it, because now he's got the grounds to do what he obviously knows he needs to do, and that is disqualify these corrupt and unethical nincompoops from this file. And there's been a very interesting development as relates to Scott McAfee's run for election for a full 4-year term. I'll get to that in a second. Suffice now to end with Harold Jones II. He is the Democrat minority who had an opportunity to ask some questions towards the end in order to, get the other voices heard and not just have it be someone who's clearly friendly to Ashliee Merchant asking the questions. Harold Jones II, Go watch my stream when I'm covering this and look at the chat. A buffoon, a dishonest buffoon. Set aside the vocal fry, set aside the fact that he was apparently eating the microphone for some reason. A buffoon who came out to argue over one specific case law, to try to argue that there was no appearance of conflict as relates to what Fani Willis and Nathan Wade did in the context of this file. No improprieties, no nothing. It's just Fani Willis bypassing Georgia law, the regulation, by the way, for those who are interested. I took a note. 15-18-20 of the Georgia state law, whatever you want to Google it, you'll see it. Bypass all of it. Nothing to see here, people, because according to Harold Jones II, neither Fani Willis nor Nathan Wade had an interest in the outcome of the verdict of this prosecution.
See, I told you.
Set aside the fact that they quite clearly had an interest in the prosecution itself, because as Ashliee Merchant astutely and amazingly explained to Harold Jones II, who was not there to listen to the answers, by mere virtue of the fact that they could incorporate her client, Michael Roman, into this case, they expanded the scope of the RICO case. It would take up days of trial. It would take up multiple trials because there were so many people involved in this case now. The scope of this RICO prosecution was massive, so massive that it allowed Fani Willis to hire Nathan Wade as external counsel. Then he comes in, hides his assets, takes Fani Willis on trips. She pays him back in cash allegedly, which she never did, and there's no record of it. Oh, but there's no appearance of conflict of interest. Hell yes, there is. And hell yes, there is an actual conflict of interest above and beyond an appearance of conflict of interest. So it was Harold Jones II, buffoon. It was just terrible, wasted time. You just knew that he was trying to get out the sound bites that the media can pick. Not the answers. He couldn't care less about the answers. The sound bites of his questions so the media can run with it and say, she didn't prove any conflict of interest, let alone an appearance. Horse crap. Anyhow, horse crap to the horse crap.
The key thing is, that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him, if that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just you're just saying the money you paid him, you could have done this, because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could have used this money for that, but that money was delegated for him.
It was never delegated.
Short term.
It was never
project,
delegated,
so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney.
What the hell are you talking
to make
about?
that decision.
No, it wasn't up to her to make that decision.
That. I just make the point.
Did this guy listen to anything?
So far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified.
And then the latest breaking development of the day, Phil Holloway, who was on my channel for the closing arguments. We had a great time. He's going to come back on later to talk about these developments. Wild. Phil Holloway tweeted out that it's no longer a non-contested race for Scott McAfee's bid for re-election or election for a full 4-year term. Really? Apparently, civil rights attorney to challenge Scott McAfee, judge in Fulton Trump case. Who's this individual? Civil rights attorney and talk radio host Robert Patillo plans to run against Fulton Superior Court Judge Scott McAfee, who has been overseeing the high-profile election interference case against former President Donald Trump and others. Patillo plans to qualify as a candidate for the position on Thursday, according to multiple people with knowledge who declined to speak on the record. He is the former executive director of the Rainbow Push Coalition, the social justice and civil rights group founded by Reverend Jesse Jackson. He's also a criminal defense attorney and a former candidate for State House who has previously billed himself as a conservative Democrat. These words mean nothing. Bottom line, this is a Reverend Jesse Jackson disciple, an activist, and now apparently is going to compete against Scott McAfee in the election for that judge's seat. If Scott McAfee had any hindrance, had any reluctance to disqualify Fani Willis from this case, I think he just lost it. If they're going to vote based on race and politics, Scott McAfee is going to lose this seat no matter what. He is a white Republican judge who was appointed by Kemp, the governor of Georgia, who's a Republican, although I don't know what Georgia Republicans look like anymore. But if race and politics are going to be the deciding factors in this, well, then Scott McAfee is going to get voted out regardless. So he may as well do the right thing and disqualify Fani Willis, unless he somehow thinks by not disqualifying Fani Willis, he's going to win the vote. Horse crap. If people are going to vote based on politics and race, Scott McAfee is going to lose regardless of whether or not he disqualifies Fani Willis. And now he has all the grounds in the world to do that. In fact, disqualify her, disqualify Nathan Wade, and maybe maybe even dismiss the charges. Who knows? And then if he loses his bid for election, his full 4-year term, well, you know what Scott McAfee's going to do? He's going to go work in-house in private counsel, and he's going to make a buttload more money than he would ever make as a judge in Georgia. Who knows what he wants to do professionally? But that's what is going to be the outcome in all likelihood. I think he has just lost whatever incentive he had to not disqualify Fani Willis. But lo and behold, pressure tactics, you got an activist now running against Scott McAfee. And if people haven't learned their lessons from having elected Fani Willis in the first place, if people aren't fed up with the corruption that is there, plain to see, I don't know what is going to be required to change their minds. I mean, it's the question that Dan Bongino always asks, is it bad enough yet? You're looking at this case, is it bad enough for you yet? By the way, you get Fani Willis lying about having gone to the White House to collude with VP Kamala Harris, it would seem, because on that little note there, her visit to the White House, it said VP in the tent on the lawn. You've got Fani Willis, corrupt to the core, squandering taxpayer dollars to give to her boyfriend so he can turn around and give it to her with gifting luxurious trips. Oh, I almost forgot. At one point, Harold Jones II, in trying to undermine the inappropriateness of these vacations that Fani Willis was taking with Nathan Wade, asked Ashliee Merchant, Forbes' article says that the average American takes a $2,000 to $4,000 vacation. So there's nothing extravagant about these vacations. The average American takes a $2,000 to $4,000 trip a year.
You know what maybe the average American spends on a vacation?
Not this much.
You don't think?
No.
Have you looked?
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, you know, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief, because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
Not 4 in a year.
Family of 4.
Right, that's less than
at
a
that
year,
time,
though.
they were taking 2 and 3 at the time.
That makes
so
sense.
That makes,
so
that's
these,
about
no,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on.
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said $3,700 for a family of 4. That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
No, the average American who can afford to go.
This is half of that for 2 people. So you said $3,700 for a family of 4. This is for 2 people.
Right, it's just 2 people.
Right. So,
so
that.
Double it.
It's more. It's double,
So
right?
it wouldn't necessarily be average. It's 2 adults. Bottom
Why are you
line is
bringing
it's
it
not
up, though?
extravagant.
It's
It's not
irrelevant.
lavish, is it?
The law
Can
only
you
says
imagine these
$100.
arrogant, pompous
not lavish.
Democrat
And that's one of the reasons I didn't
fuckers?
include all the Ubers.
Holy cows. First of all, Harold Jones II, the only Americans that take a $2,000 to $4,000 vacation a year are the ones that can afford doing it. Go take a poll, you Democratic elitist prick, to find out whether or not the average American is taking vacation, let alone a $4,000 vacation a year. But it gets even worse than that. Ashliee Merchant didn't really pull this up during the answer to these questions. It wasn't that Fani Willis and Nathan Wade took one $4,000 trip.
There you go. Come on.
They
Viva.
took 5 cruises within a 7-month period.
5
They
cruises.
took 3 in 2022 and 2 in 2023, all of which were at the very least several $1,000s. So they didn't take 1 in a year, Harold Jones II. They took 5 in 7 months. I counted it. This is the level of elitism, detachment, unreasonability of the typical Democrat politician. They think everyone is as loaded as they are. They think everyone is living the lap of luxury that they're living. Detached, and above all else, dishonest and corrupt.
Absolutely.
So you have Fani Willis elected. And if the people of Georgia haven't learned their lesson from having elected Fani Willis, go ahead and elect another activist judge and see what happens. It's worked out so well for you. That's the update. That's the summary. I hope you enjoy it. If you did, you know what to do. Like, share, subscribe, hit the notification
that
bell.
good stuff.
Viva Fry on Rumble. Viva Fry on Twitter. VivaBarnesLaw.locals.com on Locals. Stay tuned. There will be a follow-up, and I'll be going live daily with short videos, as they are warranted given what's going on in the world and the news. So get out there, talk to people, exercise, and now you know your vlog. Peace out.
All right. Grace and peace, everybody. Thank you so much for that. That was a lot of fun. All right. I'm going to, hold on one second. Sorry about that. Okay. So I pulled it up. The judge that potentially might be running against McAfee is a Clark Atlanta University graduate. So that would be interesting. I dropped his LinkedIn in there for you to check him out. Check out his background. Pray for him. Yo, this was a lot of fun. Thank y'all so much. This was wild. All right. Let me know. I don't think there's any more cases tomorrow, prayerfully, but man, there's still so much that's been popping off. I have no problem with it. If y'all want to, we'll do it again tomorrow. We'll figure out what they got going on And we will talk about it tomorrow. But I do appreciate all of you. If you could, if you haven't already, even if you didn't like it, could you give me a thumbs up? Hit the thumbs up button 3 times if you didn't like it, or hit it 1 time if you did like it. Either way, I greatly appreciate it. I'll probably try to see if I can gather together some more of Ashlee's testimony. I don't think she's doing any more tomorrow, but I'll try to gather some more and we can watch it again, have some good times checking it out, and hopefully encourage each other and encourage everyone to keep our eyes on Christ, because we see how corrupt our politicians are. We see how corrupt our senators are here in Georgia and so forth. That's another good reason why we should keep our eyes on Christ. But everybody, have a fantastic night. Thank you so much for hanging out with me tonight. Let's do this again real soon. Make sure you like, share, and subscribe. Check out my Buy Me a Coffee. Help a brother out. Buy me a cup of coffee. I'm going to need some tomorrow anyway because I'm going to be sleepy. So check me out on Buy Me a Coffee. Check me out on my dearwokec@gmail.com. All that kind of good stuff popped in. Did I put it in there? There we go. All right. All my links are right there. Let's do it again real soon. Look for the update. If there's something pop off tomorrow, I'll do it again. So until then, everybody, grace and peace. Take care.